Hello everybody, thank you for joining me today for today's webinar. I really appreciate you taking the time to take out of your day and stop and think about what's important to you and take some action. My name is Scott Schweitzer. I'm a trust and estate attorney and owner of Prime Estate Planning, and I'm happy to be with you here today. So before I go into logistics too much, I want to talk a little bit about why it is that I got into trust and estate planning. Just so you guys know, I've been an attorney for about a decade, and I've owned a real estate title company for the past 7 years. And it's given me a lot of exposure to people buying and selling property, dealing with money and so forth. More recently, about 3 years ago, I had one set of my grandparents pass away. And the good news is they had been super proactive about their estate planning. They had set up a meeting with their estate planning attorney. They had brought my mother and my uncle into the procedure. They put all their property into a revocable living trust, and so when they did pass away, there was no court proceeding, there was no probate, everything was handled efficiently, and it actually made my family come together more. We hadn't been that close, but because the process was so smooth and so collaborative, we actually now are in a better position than we were earlier, and it was just a really great experience. Unfortunately, another set of grandparents in my family, my cousin Rastania, passed away, and they had really the opposite experience. They didn't have as much in the way of assets, but at the same time their attitude was that since we don't have that much, we're not going to worry about it. We'll leave it up to our family to make those decisions and those choices after we die. And where their family was close beforehand, when their grandparents passed away, the kids started fighting. They certainly didn't have a trust in place, they didn't have a will in place, and everything, of course, was put in front of a judge. The family had to go through probate, and there were fights about little things. Who gets grandpa's wood saw? Who gets this painting? Who gets that? And the sad thing is, at the end of a 2.5-year process of litigation, the value of the estate was basically eaten up by the costs of the attorneys on all sides litigating to figure it out who gets what. And the real tragedy is that there are people in that family who are still not speaking to each other to this day. Had they known, they were a very strong family, had they known that with just a little bit of time and effort, they could have put things in a better place, I know they would have done so. So that inspired me to get into this field, and it's really the reason why I'm speaking with you here today. So in my practice, again, as a real estate attorney in a title company, I would often get clients that would come to me, and they'd set up a trust, let's say. Perhaps they're an unmarried couple. They would come in, and very, very responsible and so forth. I would refer them out to another attorney. This is before I did trust and estate planning. And I would see them like a year later when they were coming back to refinance. I would notice that the property would still be held in their individual names. And they'd come in and I'd say, oh, did you not like the attorney that I sent you to? And they would say, no, he was great. I said, okay, well, what about the trust? You decided not to create a trust. And they'd say, no, Scott, our trust is right here. We created the trust. And I would pause and I'd point out that the trust document, the planning you did, is only effective if your trust is funded, meaning that the properties that you have are appropriately owned by the trust, titled into the trust, as opposed to being left there by themselves. And I would ask them about that, and I'd get a long pause, and they'd say, you know what, the attorney told us something about having to fund the trust, but we never got around to it. We never got around to it because the attorney billed by the hour. Every time we called him, it was difficult to reach him, and in addition, we would end up with a situation where we'd get a bill at the end of every month. So we sort of just forgot about it. And I would tell them at that point, unfortunately, you just paid $5,000 for a trust plan that's not going to work for you and for your family. And, at first I was upset with the attorney, but I found more and more that this is the standard state of practice in trust and estate planning. Typically, you have clients come in, you have a consultation, they sign the documents, and you send them on your way. You don't hold them accountable for funding the trust, for making sure that the actual plan works for the family. And that's something that we're committed to doing. So, with that out of the way, the best way for you to learn today is to turn off your phone, turn off any notifications, make sure you're in a quiet place where you won't be disturbed, and we'll move on from there. Thank you. So I'm curious, do you currently have an estate plan? Some people who come to me have an elaborate estate plan that was done maybe a decade ago, but their life circumstances have changed or the law has changed. Other people are coming to me for the first time, having never done any planning. And these people come to me in their 20s, they come to me sometimes in their 80s. So I just want you to know that you're not alone. Wherever you are on this journey is the appropriate place, and I'm happy to work with you regardless of where that is. But I do want you to think about a little bit, what is it that you hope to learn here today? I find estate planning, to be curious as an academic exercise, but most people don't. And I'm willing to bet that you are here for a very specific reason. There's something in your mind, there's something in your life, whether it's someone who passed away, who now has had to go through a court probate proceeding, whether it's getting married, whether it's having kids, whether it's buying or selling property, there's something that's happened in your life that's motivated you to come here. So I want you to take a moment to just root into that, to connect to yourself, and to really remind yourself why you're here today. First of all, we understand there is this fear that planning for death will somehow hasten its occurrence. That's one reason we have heard of, but I have good news. Honestly, I've never seen a correlation between helping a family complete their plan and then something unexpectedly happening shortly thereafter. And I want you to know you are in the right place if you've ever thought of any of these things. You have someone or something you care about and want to protect. And it doesn't matter if the something is big or small, expensive or not. Maybe you're not positive a document created online will fully protect you and your family. Or maybe you're wondering whether a document created online can protect you and your family, and what is the supposed danger of do-it-yourself estate planning. If you've ever thought that, you're in the right place. Because estate planning is not about you, it's about the people you love the most. In my case, that would be my sister, Lucy, my nephew, Vaughn, and the other family members that I really am close to, the people that I know will be there, or I believe will be there after I am. I want to take care of those people, and it's important to me that I put them in the best position that I possibly can. So for you, it's going to be a little bit different. But again, think about that. Think about who it is that you're doing this for in reality. It's going to help you move on to the next step with the most confidence. Let's talk through what you will learn today. After you get off your computer, life will go on, and at some point we will die, and we may very well become incapacitated for a time. Here's my real question. What happens next? That's what we're really going to focus on today. And we will explore this from two perspectives, the before perspective and the after perspective. The before perspective is about what happens if you have no estate plan or only a document here or there when a sad day occurs. And it will occur, no doubt about it. In this case, your family is left vulnerable. What will they have to go through? For each sad day that we're going to go through, we're going to talk through the before perspective first. Another way to think about this is what the state decided. and you'll learn that what the state decided is probably not what you would decide. The after perspective is how a potentially tragic situation can be turned into the best possible scenario for you and your loved ones, keeping your family out of court and out of conflict. And as you might guess, this all comes down to communication and things being in writing, clear and comprehensive. Now let's jump into learning about estate planning by getting to know the Bliss family very well. They are going to experience some very sad days today, and we are going to learn by exploring what happens when that sad day occurs. You'll likely have questions as we go. Write these down and I'll answer the questions during the Q&A at the end. So let's meet the Bliss family. This is a great family. Mark, Molly, Alexander, Benjamin, and Caroline. Mark and Molly are happily married. They own their lovely home here in the district, and they have two wonderful children, Benjamin, who is 12, and Caroline, who is 10. Molly also has a child from a previous marriage, Alexander. They have joint checking accounts. They are putting money away from a retirement. They both have life insurance to make sure there's financial resources there if one of them were to pass, and they both came into the marriage with a little bit of savings already. They each have a solely owned investment account, and in Molly's solo account in particular, she also has an inheritance from her parents who have passed away. As I mentioned, Molly was married prior to marrying Mark. She was married to her college sweetheart, Xavier. And Xavier and Molly had a son, Alexander, who is now 15. Xavier was kind of the wild, crazy, fun guy in college, but he never settled down or got serious as a husband or a father, so it didn't last. As a result of the divorce, Molly has primary custody of Alexander, who lives with his half-siblings Benjamin and Caroline, and with stepdad Mark. And also as a result of the divorce, Xavier updated his life insurance policy. He obviously doesn't want his $1 million policy payable to Molly, his now ex-wife. He wants it payable directly to his one child, his son Alexander. So Xavier made that update on his life insurance. Honestly, that he has life insurance at all is the one responsible thing Xavier did in his mostly party-filled life. Just your everyday family, really. But this poor family is going to be really put through the ringer because they're going to have to go through quite a few sad days in a really short period of time for us to learn more together today. So I hope you'll bear with me because the ill-fated Bliss family is going to be put through just an absolute train wreck today. As a side note, I hope you can get a sense of how I approach the topic of life and death. I don't take myself too seriously, I enjoy humor, but at the same time, I want to make sure I'm conveying these really important points and teaching and educating you as part of the process. So, with this said, we're going to jump into sad day number 1. On sad day number 1, Xavier is turning 40. This is his big birthday. He wants to do something he's never done before, and he's decided he wants to go skydiving. On his 40th birthday, he steps into the plane to go skydiving, but he is just so beside himself with excitement that he doesn't pay any attention to the safety instructions, and before you know it, he is jumping out of the airplane before they even finish getting him ready with the parachute and backpack. All of a sudden, it's a skydiving gone bad scenario. Adios, Xavier. But Xavier has no estate plan. Although recall, he did do one responsible thing in his life. He had life insurance, and he named Alexander as the beneficiary. A good plan, right? Well, Xavier thought he had a plan, so to speak, by having life insurance, but what's about to unfold is anything but a thoughtful, decent plan that leaves Alexander better off. Alexander is going to be worse off. Alexander is only 15. He is a minor, so Alexander is actually pretty pumped. He's a teenage millionaire and he's really excited about that very fancy red car he's about to buy. In the meantime, Molly, as you might imagine, is nervous. She's thinking to herself, wait a minute, Alexander is only 15. $1 million is a lot of money. Can he be in charge of his own money at age 15? How can I make sure he's responsible with the money? Molly calls our office and lets us know that this is going on, and we deliver the bad news to Molly that we have to go to probate court to figure out who is going to be in charge of the $1 million until Alexander is an adult, meaning 18 years old. Probate court is required because Alexander is a minor, and minors can't be in charge of their own money. The probate court is also involved regardless of whether Xavier had a will or no legal documents in place. In terms of Alexander, Molly wants to be his guardian. As part of the process, we have to submit Molly's credit report and background check to the judge, which she considers invasive, but she has no choice. The judge, a stranger to the family, wants to see these things to make sure she is a seemingly responsible person. And in the district, if the child is 12 or older, they're also going to court, and they could be, and often are, questioned by the judge as well. By the way, everything about this court proceeding is a public record that can be searched by anyone, and it takes time. We're on the court's timetable. And guess who else shows up? Zachary, Xavier's brother. This is Xavier's life insurance money, you know. I doubt Xavier would want Molly, his ex, managing it. It seems like he would really rather have his brother Zachary manage it for Alexander. I have a question for you. Who will the judge choose as Alexander's financial conservator? Molly, Alexander's mom, or Zachary, Alexander's uncle? Here is the answer. We don't know. There is no legal requirement that the conservator be the surviving parent, and there is no legal requirement that the conservator be a blood relative of the deceased person from whom the money comes. The judge has no clue who is actually a responsible adult, because it's not their money, it's Alexander's money, and the judge needs to make sure the conservator is going to be responsible with it, because he or she will have access to the money, but they're only supposed to use it for Alexander, not vacations or fancy boats. Molly is shocked, because she knows she would never do that. She thought that this was going to be easy, and that she'll be the default conservator because she's Alexander's mom. But there is no default. And whoever the judge appoints will serve until Alexander is 18, because then he is an adult. So, all of a sudden you'll have an 18-year-old in charge of a lot of money, with no oversight, no financial understanding required, no requirement to check in with anybody. He can do with it what he wants. Imagine what he'll spend that money on when he's 18. Let's do something better for the Bliss family. Idea number 1. Xavier decides to leave the money directly to responsible brother Zachary. He thinks this is an easy, quick way to fix this situation. Lesson learned. Don't name a minor as a beneficiary. But, and this is a huge takeaway, never do this. You don't ever want to name anyone as a beneficiary who you wouldn't really want to receive the money without any restrictions attached. Xavier doesn't really want Zachary to receive the money. He wants Alexander to. He is just thinking he can get around probate court really easily. Here's why. If Zachary is the beneficiary, it's Zachary's money. As simple as that. If Zachary wants to use the money for Alexander, great. If Zachary wants to use it for himself, that's great too. He gets to decide. It's his money. And because it's Zachary's money, if Zachary goes through anything in his life where he might owe someone else some money, maybe he owes money to someone who sues him, or a creditor, or an ex-spouse, then because Zachary has ownership of all this money, someone else, who Alexander doesn't even know, can garnish the money directly from Zachary, leaving nothing for Alexander. Then Alexander is completely out of luck. None of these people have anything to do with Alexander, or what Xavier wanted for Alexander. It doesn't seem fair at all. So idea number 2. Instead, Xavier signs a simple will that says, I leave everything to Alexander. If he is under 21, I put Zachary in charge. Now everybody's probably heard that you need a will, so this sounds like it will be a good plan. And not only is he saying everything goes to Alexander, but also that if Alexander is not even under 18 but under 21, then Zachary is in charge of managing the money for Alexander in the meantime. But there's a hole in this plan that I think will surprise you. Xavier did not know that at the end of the day, 2 simple things override your will. Joint ownership and beneficiary designations override your will. I'll give you a fair warning. I'm about to go through the slide with the most words out of all the slides, but there's a good reason, I promise. Let's talk about these 3 buckets: joint ownership, beneficiary designations, and your will. Here's the thing. When someone calls me after a loved one has passed away, the first thing I want to know after is not whether they have a will. I first want to know whether they jointly owned any of their assets with anyone else. Because if they jointly owned anything, and that joint owner is still living, that surviving joint owner in most cases is going to get that asset regardless of what's in the will. Let's say that Xavier remarried. He owned a home prior to marriage, and then he added his new wife, which is Alexander's stepmom, to title. If Xavier really just wants everything, including the home, to go to his son Alexander, then in this scenario, Alexandra will not get the home. Because the stepmom is a surviving joint owner of the home, she will get the home even if Xavier's will says, I leave everything to Alexander. So joint ownership overrides Xavier's will. Then, if assets are not jointly owned, the next thing I ask is, what does the beneficiary designation say? I'm willing to bet that you have beneficiaries designated at this very moment, whether you realize it or not. Life insurance and retirement accounts are the best examples. If the beneficiary is living, like Alexander on the life insurance, then Alexander is going to receive that $1 million outright, even as a minor, even if Xavier has a will saying otherwise. This is because beneficiary designations override Xavier's will. Back to probate court. Plus, the probate judge doesn't have to choose Zachary as the conservator, even though he is named in Xavier's will. Remember, the will is not legally controlling at this point. The document's-only attorney or the online software Xavier used didn't tell him about this. He is now rolling in his grave. And then, if there are any assets left over after we go through joint ownership and beneficiary designations, those assets go into Xavier's probate estate. Xavier will now controls whatever assets fall into his probate estate, or if he didn't leave a will, state law says what happens to whatever assets fall into his probate estate. So here's surprise number one. Whenever you hear the word estate, it actually doesn't necessarily mean everything that you might own. It only includes those things that did not pass to a surviving joint owner or your designated beneficiaries. Sometimes people leave no assets that fall into their estates because the two levels above took care of all their assets. And here's surprise number two. A will goes through probate court. Remember how we were at probate court when the life insurance proceeds were paid directly to Alexander? This is the same place we have to go to file a will when someone passes away. Now you're wondering, what do I do if I don't want my loved ones to go to court? So idea number three. Xavier gets a trust instead. And in his trust he says, I leave everything to my son Alexander. If he's under 21, I put Zachary in charge. You'll notice it's the exact same thing he said in his will. How does this work? First of all, let's address the elephant in the room. What is a trust anyway? The type of trust that we're talking about is a revocable living trust. There's all sorts of types of trusts out there, a lot of which serve a lot of different purposes. But the one that we're going to talk about today is the how to avoid the probate court. In other words, how can we say who gets what, under what circumstances, and make that happen but not go through probate court? The revocable living trust is a will substitute, in that it's like a will, but doesn't go through probate court. Here are the three buckets in the context of a trust. We go through the joint ownership and beneficiary designation discussion, and we have specific steps we take for each of your assets. We don't stop working for you just because you've signed a trust document. We need to then take the steps to fund or put into your trust each of your assets one by one. First, for some assets, we will update title from your name or your joint names to the name of your trust. Second, for other assets, we will update the beneficiary designations from naming, say, your minor children to the name of your trust. And third, there is no probate estate anymore. Everything you own is in the name of your trust, and your trust itself is a private document that says who gets what under what circumstances. There is no probate court because a trust is private, making it a lot easier and more efficient for the loved ones to handle everything. Think of a trust and funding your trust like the toys in this little red wagon. When you were a kid, you loved putting toys in your little red wagon and pulling it around. And if your sibling wanted to grab your toys out of the wagon, there was probably immediately conflict. The way to avoid conflict and the exposure that comes with toys not being in your red wagon is the same with how a trust works. The probate court is avoided for the things you put inside of your wagon. The legal phrase for this is trust funding. And so long as your assets are funded to your trust, meaning all of your toys are in the red wagon, then there is no probate court to get these assets passed to your loved ones. So look at this scenario. All the toys are outside of the wagon. Here's what happened here. You signed a trust, whether in an attorney's office or something you bought online. Your trust legally exists. You signed it, great. But your trust is the empty wagon. It is not avoiding probate court, and it is inviting conflict. Would you send your child to their first day of school with a backpack that has nothing in it? Of course not. What good would an empty backpack do? You can see how this is a disconnect. We've got a trust. We've got assets outside of the trust. This is not working. This is not going to avoid probate. And this is a major danger with do-it-yourself estate planning or working with a documents-only attorney. Now, this is a much better scenario. The assets are inside the little red wagon. The takeaway is that if you have a trust in place, the biggest mistake people make is that they don't update their assets to flow through the trust and their estate goes to probate court. Here is lesson number 1. A review of all your assets must be part of your estate planning conversation. A document alone is not enough to protect you. Okay, that is everything that transpired from sad day number 1. I promise the lessons will not all take this long to cover. I wanted to cover the biggest question first, a will versus a trust. So thank you for hanging in with me. If you have any questions, do write them down so we can go over those during the Q&A. Moving now to sad day number 2. It's a fun ski weekend for the Bliss family. The whole Bliss family is having a great time skiing up in snowshoe for a long holiday weekend, and they brought their friend Dana with them. Dana is a longtime friend of the family. Dana doesn't have kids of her own, but she loves Alexander, Benjamin, and Caroline just like they were her own children. It starts as a really fun 3-day weekend on the mountain. Beautiful weather to start, but unfortunately, a fog descended on the mountain quickly. Mark and Molly, who were all going downhill very, very fast, lose sight of each other because of the fog, and before you know it, Mark and Molly totally collide into each other, and now we've got a skiing gone bad scenario. It's a total yard sale, skis and poles everywhere. And where are the kids? They're in ski school. Mark and Molly are parents of minor children. What happens in an emergency situation with minor children whose parents are injured or missing? Ski patrol tends to Mark and Molly, and first responders are helping out. A first responder sees a picture of the beautiful Bliss family in Mark's wallet, and now the first responder knows he needs to check in on the children to make sure they are safe. And the first responders decide to send them back to George Washington Hospital on a flight for life. Dana gets the children from ski school and plans to get them back to D.C. to stay with them as long as necessary. Dana calls Molly's sister Mindy in Texas to let her know what's going on. Mindy hops on a plane to D.C. to come be with her sister Molly and her niece and nephews. And here we have some questions. How long will it take Mindy to arrive? Can she get the next flight out today, or is the first flight out not until tomorrow morning? I guess Dana will stay with the children in the meantime, right? What you're about to learn may surprise you. It turns out Dana can't stay with the children. Only adult blood relatives can be the default temporary guardian when minor children are involved, and the parents don't have any legal documents otherwise. This means Dana is disqualified. She is just a friend. This is obviously a huge problem. The kids know and trust Dana, and they are safe with her. If Mark and Molly could communicate, they would say, ask their children to be supervised by Dana. But they can't communicate. And so we are stuck in this no man's land, wondering how long it will take Mindy to arrive. If you are parents of minors like my sister is, to me this is the scariest question of all, because what is happening is going to be very scary for her children. Her children won't know what's going on, and they won't understand who the strangers are. So I would want to make sure that they're going to be in the care of someone I totally trust, who I know will love them. So let's do something better for the Bliss family. Under this scenario, Mark and Molly put a short-term guardianship emergency plan into place to name Dana as a short-term guardian for her kids. Short-term guardianships are part of the kids' protection plan that we include for every client that has minor children. Because in emergency scenarios, copies of legal documents work just as well as originals. Dana could pull up the short-term legal document on her phone and show it to a first responder, a police officer, a preschool, anyone who asks. Mark and Molly have a plan. It's personalized and tailored specifically to them and their children, and it's actually going to work when they need it. Lesson number 2. Guardianship is equally about what happens in an emergency as it is about who raises your children if you can't. Sad day number 3. Molly's injuries linger. Mark recovers, but Molly is still unconscious and suffering from her injuries. Mark is making Molly's medical decisions for now, despite the emotional burden of the whole experience. Mindy just landed, and she immediately gets on the phone to the hospital. She wants to know what is going on with Molly, but she hits a big red stop sign called HIPAA. The doctors can't talk to anyone about Molly's medical condition without Molly giving explicit permission in writing. So you can see that Mindy is frazzled. She's upset. She's yelling at the doctor. But the doctor says, "I'm sorry, There's a medical privacy law called HIPAA that says I can't talk to you. Mindy slams the phone down in complete frustration. Mark has been making medical decisions for Molly before Mindy arrived, but now that Mindy is there, they legally get to make the decisions together. You may be thinking to yourself, but why? Mark is married to Molly. He should have the exclusive right to make Molly's decisions. Big surprise, no he doesn't. The law says any interested person or persons can make medical decisions for someone who's incapacitated when there's no estate plan. This means Mindy and Mark are now on an equal playing field when it comes to making medical decisions for Molly. The law doesn't presume that your spouse has your best interest at heart, or that you would personally want him or her to make your decisions. It's just any interested person or persons who can make your decisions. So we're back at the probate court. But before we go to court, Mark is trying to keep up with the medical bills as they pile up. And he's going to learn the hard way that his hands are tied as he tries to pay the bills out of Molly's account. Remember, Molly has a savings account in her own name. She had some money in there prior to the marriage, and then when she inherited some money from her parents, that's where she put the money. Mark is not an account owner. They never got around to adding his name to the account. Mark goes into the bank thinking, I'll access the account and pay Molly's bills for her. But when he arrives at the bank, he hits a brick wall. The banker tells him he can't access Molly's account because he's not an account owner. But we're married, he says. Same as with medical decisions. It doesn't matter. This may sound crazy, but Mark is having to go to probate court both to prove that he is capable of making Molly's medical decisions himself and that he is a responsible person to handle Molly's finances. Who is the judge going to choose? Mark or Mindy? Mindy is just as interested in Molly's medical and financial affairs. When it comes to the finances, Mindy is thinking, this is the inheritance from my parents, and I don't want Mark to make bad decisions with it. And she's making this very clear to the judge. Mark is really annoyed because he's thinking to himself, of course I'm trustworthy, and of course I have Molly's best interest in mind. We're married. Why can't I just access this account? This is such a big hassle. But we're at the probate court anyway, because that's what the law says you have to do when someone's name is not on an account, even when they're married, or when someone doesn't specify in advance who makes the medical decisions for them. This is a nightmare scenario for the Bliss family. Let's do something better. Now, with Molly's medical power of attorney, Mark is solely making Molly's medical decisions, even if Mindy's there in person. Now, Mindy, of course, can have very opinionated views and be as loud as she wants about any disagreements with Mark. But at the end of the day, legally, Mark has the final say-so, and we don't have to go to a probate judge for permission about that. Under Molly's HIPAA release, Mindy can call the doctors and find out what's going on. Mindy is named on the HIPAA release, even though she's not Molly's medical power of attorney to make decisions. All the HIPAA release means is open communication, and most importantly, Mindy has a copy of the HIPAA release that she provides upon the doctor's request. Remember how important copies are. With the financial power of attorney Molly signed as part of her estate plan, she names Mark as the sole decision maker regarding her finances. This means when Mark walks into the bank, he can bring the financial power of attorney with him, and he can get access to that account to pay Molly's medical bills. This is a huge time saver, because instead of having to go to probate court, Mark can immediately take this document and act under it and do this for Molly's benefit, saving him a ton of hassle and time. Here's lesson number 3. The only person other than you who can make your decisions is a probate judge. Don't let that happen. Take control. Now to switch over to how our firm's process works. I'm showing you this visual here. It's a 3-meeting process to get your estate plan in place. The initial meeting is called your family wealth planning session, and that's where we sit down one-on-one together. In advance of your planning session, you will complete your online family wealth assessment, which is an easy and secure way to provide key information about you, your family, your assets, and your values. Really important information that I will review in advance of our meeting together. At your planning session, we will hit the ground running. I will go over the engagement agreement to indicate which estate plan you choose and the flat fee, and you'll sign and make payment at that meeting. And then I will meet with you about 4 weeks later at your signing ceremony. This is when your plan legally is in place. At your signing ceremony, you pay the balance of the fee, and then a few weeks later, we'll meet for your final meeting. And this final meeting is where we really focus on the most important aspect of your plan, that your plan is an evolving thing as you and your family grow and change. And what's important is that all of these meetings can be conducted virtually, as well as an in-person. All right, you made it through. You made it through the story of the Bliss family. Thank you for sticking with me. Just to recap the things that we've learned today, there are a lot of specifics about the law and how it relates to your family, but I just want to emphasize the traditional experience that a lot of people have with estate planning. Hourly fees, knee-jerk response to problems, kind of that sense that you're just a transaction. That's really what I'm here to counteract. The experience working with us is going to be a flat fee. It's going to be agreed to in advance, which includes work that we do with you during the process and thereafter. We're doing planning that's proactive to avoid problems, and we're relationship based. So we are going to get to know you, we're going to stay in touch with you, and we're going to introduce you to our network of professionals, people in this area, people who can help you out, people that you want to work with. So my promise to you is that your estate plan will leave no stone unturned. It will give you the peace of mind that your loved ones and your assets are kept out of court and out of conflict when something happens to you. This is going to be a different promise to every client, to every family, because you all have specific needs. Well, the one consistent thing that I want you to realize is that when working with me and working with my team, you have peace of mind. I mentioned earlier that there's a bonus for staying on to the end, so congratulations for sticking it out with me. You've learned a lot about estate planning today, and you've learned about it in terms of the Bliss family. You've learned about it in general terms, but I'm willing to bet for the most of you, you're on here because you're concerned about how this applies to you, how it applies to you and your family. And so when you think about it that way, your next step is most likely to schedule a family wealth planning session with our office so that you can get clear about your next steps to keep your family out of court and out of conflict. And what I find is one of the biggest threats to not getting your planning done is procrastination. I talked about this in the context of my relatives who put off planning and ended up with their family in conflict. It's also relevant to me. When I first got into this field, I didn't think that I really needed to do estate planning, and I put it off. When I finally got around to it, I realized that I have epilepsy, and I bike to the office every day, and I was at heightened risk for getting into an accident that would either leave me dead or incapacitated. And I had chosen my parents as the trustees to my trust. But after I gave it a little more thought, I realized that neither of them are attorneys, and neither of them have the right licenses in place to manage my client files and the client funds that I have under escrow accounts. And if I were to be incapacitated and I were to die, my parents would be in a situation where not only are they grieving, but they're actually dealing with litigation from my clients, trying to get access to their money. And I had a real aha moment. So what I did was I actually put in place a trust protector. Little technical term, but trust protector, in this case with someone who's licensed to run my businesses, wind them down, or sell them, while my parents handle the rest of my estate. And once I did that, I had a great peace of mind. And then finally, another example is I meet a lot of couples that are in conflict. Couples that have wanted to do their estate planning for a long time, but they had differing needs, and they couldn't figure out a way to actually make both of those work. And so they decided to do nothing because they would fight whenever they talk about it. And these people would finally come in, and you could sense the tension in the air. But one of my favorite things was I would come up with a creative solution that would address both of their needs, and they'd walk away so happy. And actually, sometimes I would end up getting flowers from them afterwards, which was always really nice. It always meant to me that I was doing a great job. So whatever procrastination you're experiencing, or whatever resistance you have, I think it's important that you get over that and you move forward, because you're going to feel better, and your family is going to appreciate the fact that you've gone ahead and done the planning that you know you need to do. So to circle back to the bonus for attending the webinar, what I'm offering is $1,000 in free legal services. I typically charge $750 for the family wealth planning session, and that's 2 hours of planning work with me, strategy work. I'm going to give this free to anybody who's attended this webinar if you complete your homework at least 2 days before your family wealth planning session. What that means is when you sign up, you're going to get a form, a series of questions. It's going to ask you about your finances, it's going to ask you about your family, and it's going to ask you about your financial priorities and so forth, and your estate planning priorities. And I waive the cost if you get this done free, and it's beneficial both to me because it gives me the information that I need to know to help you with planning, and it's also beneficial to you because it helps you get clear on what your priorities are, who your potential fiduciaries are, and also what assets you have. It's amazing how many people actually don't know where their assets, where their money's at. And that's why the state gets all these unclaimed assets and so forth. So it's kind of a win-win. It's a win for me and it's a win for you. Also, for attending the webinar, you're getting $250 off of any legal services that you incur going forward. So any planning that we do, you get a reduction in cost for that. So I want to let you know that I take a maximum of 6 new clients per month, and normally only 4, because I balance my community activities and I have another business helping people settle on the real estate transactions. So my time is limited. I'd like to be able to meet with everyone here today, but that's not always possible. So if you check out the chat box, you'll see a link in there for booking your family wealth planning session. If you feel like today you are ready to move forward and to do your homework and to come in and meet with me, go ahead and book this so you can claim your $1,000 off and you can make the most of this opportunity. There's another link in the chat box to what I call a golden ticket, and that is for those of you who aren't quite ready to book your family wealth planning session right now, but you want to go home and you want to think about it. Perhaps you want to consult with your spouse. You have 48 hours to reclaim or redeem your golden ticket and get the same benefit that you would if you booked your family wealth planning session today. So I encourage you to go forward and to do what's right for your family, and I look forward to working with you individually.